Good afternoon and welcome to Suspension and Debarment and the Acquisition Workforce and What You Need to Know. My name is Maria Swaby and I am the Director of the Suspension and Debarment Division at the General Services Administration. And with me is my colleague Danielle Mansfield, who will be conducting this training along with me. This training will have two parts. I will conduct the first part of the training and go into some detail about suspension and debarment and how it works. And Danielle will conduct the second part, and she will cover the role of the acquisition workforce in suspension and debarment. We will also have a question and answer section at the end of the presentation. And for your information, the entire presentation will be made available on fai.gov at some point in the near future. With that, let's get started. So the learning objectives today are to understand the purpose of suspension and debarment, the similarities and differences between suspension and debarment, and to understand the concept of present responsibility and what makes a contractor presently responsible. Also want to learn about the effects of suspension and debarment and how suspension and debarment works. It's also important to know why it is important to follow the FAR requirements, especially the acquisition workforce, and finally, how the acquisition workforce can help prevent fraud, waste, corruption, and abuse through proper reporting and collaboration. Let me start off by saying that suspension and debarment has a wide effect government-wide. So the chart here, you see the number of suspensions and debarments and proposals for debarments that took place in 2011. And if you add up those numbers, almost 6,000 contractors, either companies or individual, were suspended or debarred government-wide in 2011. So it does have a far-reaching effect on the contracting population. So what is the purpose of suspension and debarment? Well, there are several reasons, and I will go over the policy reasons right now. The first is that the federal government only does business with responsible contractors. And the FAR section that regulates suspension and debarment is FAR 9.4, which will be referred to several times during this presentation. There is a system for award management called SAM, which you should be familiar with by now as part of the acquisition workforce. And anybody who is suspended or debarred or excluded from doing business with the government is listed on the SAM, which can be found at sam.gov. This is the same as the excluded parties list system that has been shifted over into the SAM. You may know it as EPLS. So each federal government agency is required to have a suspension and debarment program. And a suspension and debarment action by one agency's suspension and debarment official, and I will refer to the suspension and debarment official as SDO for short during the rest of the presentation. As I said, each suspension and debarment action is effective for all federal government agencies. The decision is reciprocal between agencies. So, for example, if GSA suspends or debars a contractor, the U.S. Air Force must honor this decision and cannot contract with a contractor unless compelling needs determination is made by an agency head. And we will cover compelling needs determination more in detail later. So the other thing that is important to know about suspension and debarment policy-wise is that there is an organization called the Interagency Suspension and Debarment Committee. We refer to it as ISDC for short. And it is all the suspension and debarment program staff across the federal government meet and are part of this suspension and debarment committee. We meet once a month, and we discuss common practices, and we coordinate S&D matters among federal government agencies. Another policy reason for suspension and debarment is that it is the way to protect the federal government from contractors that are not presently responsible. It's not intended as a tool for punishment. We do have avenues for that. Mostly the Department of Justice takes care of the punishment of a contractor, but the purpose is to protect the government from doing business with non-responsible contractors. It's therefore a business decision. So the SDO might have reasons legally to suspend a contractor, but for business reasons in his or her discretion might decide that suspension or debarment is not necessary at this time, as it would be not in the best interest of the government. And there is a difference between the discretionary debarments that we're talking about right now today and other mandatory or statutory debarments which other agencies are compelled to do, such as HHS, for example. But in the example of let me give an example of suspension and debarment as a business decision. If GSA is leasing a building to 3 other federal government agencies, and the leasing specialist is about to exercise an option. At the same time, GSA has information that indicates suspension of the contractor is necessary to protect the government's interests. This is problematic. The leasing specialist has insufficient time to complete the requirement. The SDO, given his or her discretion, has some options. One, the SDO can wait until the option is exercised and then suspend the contractor, or the SDO can suspend the contractor and a compelling needs determination can be made to allow the single-year extension, allowing the agencies to continue to have the space and the leasing specialist to procure a new space while still protecting the government from the contractor obtaining additional work outside of the 1-year extension. Okay, so what is suspension and debarment? And as I said before, that is governed by FAR 9.4, which every acquisition workforce of employees should be familiar with, and especially contracting officers or contracting specialists. So suspension, according to FAR 9.407, is a temporary exclusion used only when the government needs immediate protection. It's generally used when the facts about possible wrongdoing are still being developed through an investigation or legal proceedings. The basis required for a suspension actually is that the SDO needs information sufficient to support the reasonable belief that a particular act or omission occur, and this is called adequate evidence. What is a proposed debarment? And that is the stage between a suspension and a debarment, and that is also governed by FAR 9.4. And a proposed or a proposal for debarment is an exclusion from federal procurement and non-procurement programs for a specified period of time, and it's used when an investigation or legal proceedings have completed. So, and that definition is good for both debarment and proposal for debarment. And so this is a 2-step process. First, you have a proposal for debarment and then a debarment. The proposal for debarment might lead people to think that the exclusion has not yet occurred, but it is important to note that a proposal for debarment does also lead to an immediate exclusion from doing business with the government, and that entity or individual is listed on sam.gov. In order for a proposed debarment or a debarment to meet the required standard of evidence, there needs to be either a civil judgment or a conviction. But in the absence of a court decision, evidence that leads to the conclusion that it is more probably true than not that a wrongdoing or an omission or an act occurred is sufficient to meet this basis. So when a contractor is suspended or debarred, what happens? They do, and the FAR outlines this, they do need to get notified of that suspension or debarment. So they would get, the contractor or the individual will get a suspension notice or a notice of proposed debarment or a debarment notice. And this definitely has some effects on the contractor, and they're immediate, and especially the immediate and government-wide exclusion from federal procurement and non-procurement programs. The duration of suspension and debarment. For suspension, suspension generally lasts up to 12 months before legal proceedings are initiated, And then once legal proceedings are once legal proceedings are initiated, the suspension may stay in effect until the proceedings are completed. The debarment is typically 3 years, maybe longer or shorter depending on the facts of the case. There have been instances where there have been debarments for 5 years, and there are rare instances where a company or an individual may have been debarred for longer than that, 10 years to indefinite. So who can be suspended and debarred or debarred? Those companies or individuals directly involved in wrongdoing that either have submitted offers for, have been awarded, or reasonably may submit offers for a government contract, or reasonably may be expected to do business with the government as an agent or representative of another contractor. So let me give you an example of an individual who may be suspended or debarred. Former contractor employee that did work with the federal government has knowledge, skills, and experience that makes him or her likely to seek employment with another contractor. So that individual is somebody who could be eligible for suspension and debarment. Another example is a former acquisition workforce members or federal employees. So it's important for you to know that as acquisition workforce members, you too can be suspended or debarred. And I'll give you an example of a former employee. If there's a former high-level government official, like an SES, who misused government travel cards for massages, expensive dinners, all paid for by the taxpayer, it is important to protect the government from this kind of individual, because there's concern that the individual would seek employment with a contractor based on his or her significant federal experience and skills. So that is an example of a former government employee who might be suspended or debarred based on their actions. Continuing with who can be suspended and debarred, there's some examples of reasons that would be a basis for suspension debarment consideration for a former federal worker. So if a former federal employee abused his or her warrant, and that could apply to the case of the contracting officer, or if this worker disclosed procurement sensitive information, or misused government property, or stole a gas card. So for an example, a federal employee who used a gas card to fuel a personal vehicle is someone that could be suspended or debarred for the use of improper use of the card. Then also a federal employee who used a gas card to fuel the vehicles of others, charged less than the market value for gas, and pocketed the money. This individual could be suspended or debarred, and through the use of the fuel card, the government was charged for that gas, but the government did not get the use of that gas as it was intended. It's important to note that we typically do not take action against federal government employees that are current. Typically, there is a termination action first before the termination of an employment action first before a suspension and debarment action would be taken against a federal government employee. A special note, I do want to note that we do look on elected public officials as persons who are qualified for suspension and debarment. While there typically is no direct nexus to an agency, it is important for public policy reasons to take action against former officials despite the lack of nexus to a particular government agency. Okay. Another set of entities that can be suspended or debarred are companies or individuals not directly involved in wrongdoing, and this is done through two methods: affiliation and imputation. And I'm going to go through each of them separately because they are kind of detailed, but they're worth understanding because this does happen quite a bit in the suspension and debarment world. Affiliation, according to FAR 9.403, involves business concerns or organizations or individuals who are affiliated with each other directly or indirectly if either one controls or has a power to control the other, or two, a third party controls or has a power to control both. So the basis for the determination of affiliation is the ability to control. So let me give an example to illustrate this. Bob is the owner and president of an IT company and is convicted of violating the Procurement Integrity Act because he obtained procurement sensitive information related to a procurement that he bid on with the IT company. He is proposed for debarment on this basis. Bob also owns and is president of a consulting firm. His proposed debarment can be extended to the consulting firm based on his ability to control both companies, and that illustrates how affiliation works. There are other means by which entities or individuals can be suspended or debarred indirectly by association with a wrongdoer is by imputation. And the FAR outlines 3 ways that imputation can work. I'm going to go through each one and I'm going to present an example. So according to the FAR 9.406-5, imputation is defined as thus: the fraudulent, criminal, or seriously improper conduct of any officer, director, shareholder, partner, employee, or other individual associated with a contractor may be imputed to the contractor when the conduct occurred in connection with the individual's performance of duties for or on behalf of the contractor, or with the contractor's knowledge, approval, or acquiescence. Rather long definition. I think you'll understand it better when I use an example. So remember the example that we talked about earlier with Bob. So if Bob got convicted for his violation of the Procurement Integrity Act, his conviction can be imputed to his IT company because 1, he is an officer of the IT company, and 2, his act occurred in connection with his performance of his duties on behalf of the IT company. And so that's why his conviction can be imputed to the IT company. The other example of imputation is that the fraudulent, criminal, or other seriously improper conduct of a contractor may be imputed to any officer, director, shareholder, partner, employee, or other individual associated with the contractor who participated in, knew of, or had reason to know of the contractor's conduct. So let me give another example. Let's use Bob's IT company again. So if Bob's IT company is indicted for stealing proprietary information and is proposed for debarment on this basis, Susie, who is the vice president of this company, knew that the theft of the proprietary information from a competitor was occurring. However, she looked the other way as the information would help them on an upcoming bid. In this scenario, the IT company's actions can be imputed to Susie. And the third and final example of imputation is this: the fraudulent, criminal, or other seriously improper conduct of one contractor participating in a joint venture or similar arrangement may be imputed to participating contractors if the conduct occurred for or on behalf of the joint venture or similar arrangement, or with the knowledge, approval, or acquiescence of these contractors. Acceptance of the benefits derived from the conduct shall be evidence of such knowledge, approval, or acquiescence. So let's go back to the Bob's IT company as an example again. So Bob's IT company is a small business and enters into a joint venture with another company that distributes software and hardware to the government. The other company has been provided counterfeit hardware to the government. Bob's IT company knows that this is occurring and fails to report it to the client, government agencies, or to law enforcement. The other company is indicted and suspended. This suspension may be imputed to Bob's IT company based on the joint venture and on his company's knowledge of the actions. So, what are the causes for suspension debarment? There are many, and the list is not exhaustive here. I will go through some of them. These are the main ones that we encounter in our practice. So, an entity or a company or an individual may be suspended or debarred based on a conviction or a civil judgment for committing fraud or a criminal offense in connection with obtaining, attempting to obtain, or performing a public contract or subcontract. So the question often comes up whether a termination for default can be a cause for suspension. The answer is yes, it can, because poor performance on a contract is a reason for suspension and debarment. Another reason is violating antitrust statutes related to offer submissions. Also, the commission of embezzlement, theft, forgery, bribery, falsification or destruction of records, making false statements, tax evasion, violating federal criminal tax laws, or receiving stolen property. Also, intentionally using Made in America or similar inscription on an item sold or shipped to the U.S., or outlying errors when it was not made in either of those places, or committing other offenses indicating a lack of business integrity or business honesty, the violation of the Drug-Free Workplace Act, and violations of terms of government contracts or subcontracts that are so serious as to justify debarment. For example, a willful failure to perform on one or more contracts, or a history of failure to perform or unsatisfactory performance on one or more contracts. Also, committing unfair trade practices is a cause for debarment, and being delinquent on your federal taxes in excess of $3,000 could also be a cause for debarment. Another cause is a knowing failure of a principal of a contractor to timely disclose to the government in connection with award performance or closeout of the contract or subcontract, either credible evidence of violations of certain criminal laws, the Civil False Claims Act, and significant overpayments on a contract. This normally happens, especially on the Civil False Claims Act, in the submission of invoices and incorrect invoices. That's where the cases normally occur. And also, failure to comply with the Immigration and Nationality Act, and the catch-all phrase is for any other cause of so serious and compelling a nature that it affects the present responsibility of the contractor or the subcontractor. So as you can see, the causes for suspension and debarment are pretty broad, and it's important to know that there is a wide net out there, and it's just important to actually follow the rules, and for businesses and individuals to act with integrity and honesty. So the causes for suspension and debarment can be either judicially based or fact based. So it can come either from a court case or just from facts that are outside of the court. And so fact based grounds often come from issues brought to the SDO's attention through the Office of the Inspector General's contract audits. I'll refer to that as OIG office from here on out, and then also from OIG investigations, from disclosures from contractors, and from the acquisition workforce reports of violations. So, for example, a CEO's disclosure to the SDO that a contractor has been fraudulently submitting counterfeit products from a well-known manufacturer as its own is an example of an acquisition workforce member reporting something that is a cause for debarment. As I said before, terminations for default are also a basis for referral. However, SDOs do not frequently hear about them, and this is where the role of the acquisition workforce comes in, because you're the people that actually know about these things, and it's important to report these actions to the SDO if you know that these have occurred. It's also important to know that the cause for suspension debarment does not need to relate directly to the work on a federal government contract. It can be for something outside of a federal government contract. So if there is a newspaper article in the Washington Post that says such and such contractor or the president of such and such contractor has been convicted or indicted for some kind of crime, that can be the basis of a suspension and debarment for that contractor or for that individual. Okay. So when a contractor or an individual has received a notice of suspension or debarment or proposal for debarment, that contractor has the opportunity to respond to that action. And so the notice letter normally affords the contractor 30 days to respond and to submit arguments and supporting documents against the action. The contractor may obtain the administrative record upon which the action is based, and the contractor may respond on its own or with the assistance of an attorney. The contractor must demonstrate to the satisfaction of the SDO that the contractor is presently responsible in order for the SDO to possibly change his or her mind and lift the suspension or debarment. And I will get into to what present responsibility means right now, because that is the underpinning of decisions of the SDO for whether or not to take suspension and debarment action. So present responsibility, as is referred to in 9.4, is distinct and different from the FAR 9.1 responsibility determination that contracting officers generally make. The 9.1 determination is contract specifics and looks at, among other things, whether the company has the resources necessary to complete the specific contract. Example, financial resources, ability to meet performance goals, possession or access to facilities, etc. Present responsibility, in the way the SDO looks at it, it looks holistically at the contractor. The SDO is not looking at its ability to perform on just one contract, but rather on its ability to be a good partner to the federal government. This assessment comes only after there is a common understanding of what the underlying misconduct of the contractor is or was. So the SDO asks the contractor, because what he wants to find out is whether, despite the contractor's prior misconduct, is the contractor responsible. So this is what I mean when I said that suspension and debarment is for the protection of the government, not for the punishment earlier. It's that, yes, there's an acknowledgement that there is wrongdoing, and even so, is it necessary still to protect the government interest? If it was punishment, then we would probably automatically suspend or debar based on the fact that the wrongdoing has occurred. But this theory of present responsibility is where the protection aspect comes from, because there is a determination that despite the bad act that happened, from where we are today, presently, has the contractor done anything to remedy the situation? Has the contractor done enough to show that they, despite that act that occurred in the past, that they are now currently responsible and the government can do business with them? So the SDO is trying to find out whether or not the contractor can be trusted to perform in accordance with the contract requirements, the law, and also to just conduct themselves ethically. So the SDO's inquiry focuses on the perceived ability of a contractor to contract with the government in a responsible manner. So the SDO's inquiry into the contractor's present responsibility generally focuses on 4 areas: 1, honesty; 2, integrity; 3, competence; and 4, any other case-specific areas. Okay. So there are also some mitigating factors that the FAR talks about, and these mitigating factors are factors that the SDO may look at and examine to make a determination of present responsibility, and also to decide whether or not continued suspension and debarment is warranted or it should be lifted. And there are about 10 outlined in FAR 9.406-1. The first one is standards of conduct. And here the SDO is looking to see whether or not the contractor had effective standards of conduct and internal controls in place at the time of the alleged wrongdoing or misconduct, or prior to that act or omission. Did they adopt such procedures or prior to any government investigation of the activity that led to the cause for debarment. The other factor is voluntary disclosure, and that is whether or not the contractor brought the activity that's cited as a cause for debarment or suspension to the attention of the appropriate government agency in a timely manner. Also, was there an internal investigation conducted once the contractor found out about the misconduct or the alleged bad act or whatever the cause for the suspension debarment was? So if the contractor did conduct an investigation, whether that the results of those investigations were made available to the suspension and debarment official. And the suspension and debarment official does tend to ask for the results of those investigations if they were not yet made available. The SDO also looks on whether the contractor fully cooperated with the government during the investigation or any court or administrative action, and also looks at whether or not costs were paid or agreed to be paid for criminal, civil, and administrative liability for the improper investigation. For the improper conduct. And then if there is an employee involved in the wrongdoing, the SDO is going to look on how the contractor handled that employee or whether or not the contractor has taken appropriate disciplinary action against the individuals that were responsible for the wrongdoing, including and up to termination of employment. The SDO will also look to whether or not the contractor has implemented or agreed to implement remedial measures, including any measures identified by the government. It is also important for the contractor to demonstrate that there is some ethical training going on in the company. So the SDO will look to whether or not the contractor has instituted or agreed to institute new or revised review and control procedures and ethics training programs. Also, the SDO will look to see whether an adequate amount of time has passed to allow the contractor to eliminate the circumstances within the contractor's organization that led to the cause for debarment. And finally, the SDO looks to see whether there is a recognition on the part of the management of the company or recognition on the part of the individual that the alleged misconduct or wrongdoing was serious and that either individual or company has implemented measures to prevent a reoccurrence of such misconduct or alleged wrongdoing. So what are the effects of suspension debarment? They're pretty drastic, and it's a position where nobody wants to be in, and you, of course, as an acquisition workforce would never want to be in this situation because they do have some far-reaching effects. And so FAR 9.405 does outline quite a few of the effects, which I'll go through some here, and then we'll also cover some that they're not included in the FAR. But the first thing is that a contractor is excluded from receiving contracts unless there is a compelling reason for receiving the contract. They're also excluded as serving as a contractor on a federal contract and excluded from conducting business with the government as agents or representatives of other contractors, which means that you cannot become an employee of a federal government contractor if you're suspended or debarred. They're also excluded from acting as individual sureties, and contracting officers must reject bids submitted from excluded contractors, again, unless there's a compelling needs determination made. In addition, proposals, quotations, or offers submitted by excluded contractors should not be evaluated for award or included in the competitive range, nor shall discussions be conducted with ineligible offerors unless, again, there are compelling needs determinations made. Okay. Continuing with the effects of suspension and debarment, contracts and subcontracts held at the time excluded can continue. However, unless a compelling needs determination is made, the agency cannot place orders exceeding the guaranteed minimum under IDIQ contracts and cannot place orders under optional FSS contracts, BPAs, and basic order and agreements, nor can they add new work, exercise options, or extend current contracts. So it's important to note that suspension and debarment applies going forward. So you do not have to terminate a contract because a contractor is suspended and debarred. However, there are limitations, and it's important to know those as outlined in FAR 9.406. I also want to note that while there may be no immediate action the CO must take if the current contractor is excluded, this will affect the contracting officer's work when time to exercise the option or procure the requirement comes up. There are also some other collateral effects of suspension debarment that are not listed in the FAR, but number one is the potential ruin of a business of a government contractor. If this is your sole business, or it's a majority of your business, or a large part of your business, then being prevented from doing business with the government will lead to ruin of the business. It also leads to the reputational damage of the business and the individual. And there's a loss of goodwill, revenue, security clearance, or specialty license that could also occur as a result of suspension and debarment. There is also a contraction of credit and denial of loans. And I could tell you, I get dozens of phone calls all the time from banks or lending institutions who are doing the background checks on applicants for mortgages. And if your name appears on that list, your mortgage will be denied. And they not only check out the mortgage applicant, but they check out the real estate agent, the appraiser. So if you're buying a house, it is very important for you to put the name of your real estate agent and your appraiser and anybody in that process through the sam.gov system to check to see if their names are there, because you do not want to get to closing and find out that your loan will be denied because that person is listed on sam.gov. The suspension and debarment also leads to some disadvantage when competing for state contracts. Some states, not all, but some states sometimes look on the federal debarment list to decide whether or not they will award contracts, state contracts, to contractors. So, who is involved in the suspension debarment case? I'm going to go over the GSA model just so you can understand the process. Well, we have several parties. We have first the Office of Inspector General. They generally do the investigations and provide our office with a referral. You have, of course, the acquisition workforce, which is you, and especially the contracting officer, the contract specialist, and the contracting officer's representatives are key in this process, and Danielle will later talk about your roles. We also have, of course, the suspension and debarment official, the suspension and debarment staff at the agency, and the agency legal counsel. The contractor, of course, is involved, and the contractor counsel if retained. I want to make an important note here. It is important to know, and I hope you are never, ever have to defend yourselves against suspension and debarment, but if you are ever in this situation, it is important to know that who you choose as an attorney is very important. If you hire counsel, you need to hire counsel that has experience with government contracts and or suspension and debarment. If you hire somebody who does not understand how suspension and debarment works, it might hurt you rather than help you. What we see that come in front of us are attorneys who may have defended their clients in the criminal case, or and they come in front of us with the assumption that they're in front of a courtroom and that they're litigating and that they cannot admit any wrongdoing. That is the complete opposite of what we expect. We do expect an admission that something went wrong in order to determine that there is present responsibility. So it is very important for your attorney to know how it works. It's almost better to come by yourself and not with an attorney if you hire an attorney that does not know this area of law. So let me just explain the GSA model of how a suspension debarment case is initiated and processed. First, our office receives from the Office of Inspector General information or from the acquisition workforce or from disclosure from a contractor, evidence that typically leads to an assessment of whether it is necessary or not to take action. So that referral is processed by the Suspension Debarment Division in GSA, and that consists of reviewing referrals and drafting internal memoranda and reviewing. And it's important to know that this review process differs agency by agency. And based on the recommendation in the decision memoranda, a decision letter by the SDO could be issued, either suspending or debarring or proposing that contractor for suspension and debarment. The contractor, of course, has this opportunity to oppose the action and explain why the contractor is presently responsible. And we highly recommend this process for anybody who's involved. We do find that a lot of small businesses tend not to respond, and that is detrimental. But it is advisable to respond rather than not respond. And the contractor may submit written matters in opposition to this proposed suspension or proposed debarment, or the suspension or the debarment, and may request to meet with the suspension debarment official in person to explain their case. I had mentioned earlier the Interagency Suspension and Debarment Committee. I do want to say another word on that committee, that it is comprised of the suspension debarment staff from civilian and defense agencies, and it's a forum where we coordinate suspension and debarment efforts, and we share best practices about suspension and debarment. So sometimes the federal government gets teased that we don't talk to each other. In this case, in the suspension and debarment world, we actually do talk to each other across the federal government. Okay. All right. I am going to turn it over to my colleague Danielle Monsfield, who will then discuss the role of the acquisition workforce in suspension and debarment.
First, we'll talk about the contracting officer or contract specialist's role. The contracting officer is required by federal acquisition regulations to check the system for award management twice to ensure that the offeror or potential awardee has not been excluded from federal procurement or non-procurement programs through suspension and debarment. The times that the contracting officer is required to check SAM is first with the opening of bids or the receipt of proposals, and at this time, any offerors who are excluded, these bids must be rejected unless there's a compelling needs determination made by the head of an agency. Also, the contracting officer is required to check SAM immediately prior to award of the contract as required by FAR 9.405 D4. Why the second award check? Why is this so important? Because suspension and debarment officials throughout the federal government take action excluding contractors on a daily basis. As Maria mentioned, over 6,000 actions, or approximately 6,000 actions against contractors were taken in fiscal year 11. Exclusions happen every day, and a contractor can be excluded between the time that a contractor submits bids and the time that an award on that procurement is made. Taking a brief step back to talk about the system for award management, we have referred to this throughout the presentation. This is a system that combines federal procurement systems and the catalog of federal domestic assistance. The system for award management is comprised of a number of systems that will be integrated in different phases. The first phase that was completed in the summer of 2012 included the combination of what was known formerly as the Excluded Parties List System, EPLS, the Central Contractor Registry, or CCR, Online Representations and Certifications Application, otherwise known as ORCA, as well as the Federal Agency Registration, or FedReg. Therefore, note that there's a lot of data in this system, and it is important to understand what data you are calling up when you enter a contractor's name. There are entity entries and exclusion entries, and make sure that if you're looking to rule out a contractor and the contractor comes up as a positive hit, that what you're looking at is an exclusion entry, not just an entity entry that is required as had been under CCR. Going back more broadly to the contracting officer or contracting specialist's role, this individual must take care not to give additional work, extend options, etc., on contracts that are awarded to a contractor prior to their exclusion, unless a compelling needs determination has been made by the head of an agency. The individual must also document poor performance, and to do so, the contracting officer or specialist should go through any applicable office procedures for this process. Poor performance is extremely important as a basis of exclusion from federal procurement and non-procurement programs, and the documentation is even more vital. In order to build a strong case so that the suspension and debarment official has an adequate record to take action, there needs to be documentation, starting with the wrongdoings or alleged wrongdoings by the contracting officer. Additionally, this individual must properly enter any terminations for default into FAPIS, the Federal Awardee Performance Information and Integrity System. This is a source of referrals to our office from the Office of Inspector General. It's also very important to put this on here in a timely manner and in a complete manner because the Office of Federal Procurement Policy has a strong push on data and having quality and timely data entries into systems such as FAPIS. Additionally, the contracting officer or contracting specialist needs to follow FAR requirements when working with contractors. This becomes a problem when contracting officers or specialists do not follow FAR requirements, and then an incident is referred to the suspension or debarment official, and the agency has unclean hands. What do I mean by that? A couple examples. First, a case could happen where an agency does not properly develop requirements for a procurement, no measurable objectives or deliverables. An Office of Inspector General can perform a pre- or post-award audit, in this case it would be a post-award audit, and find that the contractor did not give any value to the government for their services. The problem here is there is a fine line between did the contractor just not perform, or were there not deliverables that could be given in light of the poor execution of the procurement by the government here. So it would have been important for the contracting officer or specialist here to make sure that the procurement was done properly, giving measurable objectives. Therefore, the contractor could be properly evaluated when an audit would occur. Another example is based off of a real case where an agency effectively gave a contractor a go-ahead on a Recovery Act-funded project to provide materials that were not compliant with the Trade Agreements Act. Later, in a suspension and debarment hearing, a contractor, the one at issue here, attempted to use this approval or acquiescence by the contracting officer, depending on what side you may take, as a defense to the suspension and debarment official, stating that the contractor willingly and knowingly provided materials on a Recovery Act contract in violation of the Trade Agreement Act. There is ambiguity between where the contractor went wrong and where the agency was wrong. So just be sure to follow FAR requirements, double check what the FAR says before responding to a contractor. Can help make cases more clear when they come before a suspension and debarment official, and can help the suspension and debarment official root out problematic contractors more easily. Additionally, the contracting officer or specialist should engage with the Office of Inspector General when an issue or suspicion of wrongdoing, whether it's an act or a failure to act, arises, as well as with significant overpayment issues. Contracting officers and contracting specialists also have a new responsibility to consult with suspension and debarment officials on tax delinquency and federal felony conviction issues with contractors. Public Laws 112-55 and 112-74 prohibit the award of contracts, grants, or cooperative agreements using funds from the 2012 Appropriations Act to corporations that have been convicted of a felony within the preceding 24 months or have unpaid tax delinquencies. This prohibition is in place unless the agency's suspension and debarment official has considered suspension and debarment of this corporation and has made a determination that no further action is necessary to protect the government's interests. There's some challenges in implementing these laws. First, the law is poorly written, an agency versus the agency. There is a question about to which government agencies the contracting officer and the contractor must obtain these waivers. There's delay in procurement process. This might encourage forum shopping, and there's also FAR implementation issues given the ambiguous language. Switching gears here to look at the contracting officer's representative roles. First, the contracting officer representative should maintain clean hands and encourage contractors to stay out of trouble with suspension and debarment. In maintaining clean hands, what I mean there is respecting and acknowledging the limitations of your authority, not going beyond its scope to tell a contractor that they must do something when that is not your role to do so. Instead, you should defer to the contracting officer and the limitations of authority as set out within the contract and the duties set forth within the contract that the contractor must complete. You should assist in the documentation and reporting of lack of contractor performance or poor contractor performance to the contracting officer. You have a unique role here. You are on the ground with the contractor. You are the individual that engages with the contractor on the most regular basis, that has a direct ear to the contracting officer. You therefore have a unique role in preventing fraud, waste, and abuse because you are that front line. You see issues that others may not, that could easily get brushed under the rug. When you see an issue that calls out to you from contractor, either an act, a wrongdoing, or a failure to act, take the 10 minutes, document it, provide it to the contracting officer, and start building that record. Additionally, assisting the contracting officer with collaborating with the particular federal agency's Office of Inspector General in terms of reviewing contractors who've been flagged for a wrongdoing. Talking to the acquisition workforce generally, making referrals to the Office of Inspector Generals and or suspension and debarment officials regarding contractors who should be considered for suspension and debarment. This means either the contractor generally, whether it is large contractor A or the individual contractors working for the contractor. Because remember, as Maria stated, a contractor is contemplated by FAR 9.4 for suspension and debarment is not only that company, but also the individuals therein, whether they are your day-to-day employees or higher level executives who are the ones who are submitting bids for possible award. Additionally, information of wrongdoing or alleged wrongdoing does not need to be related to contractor performance. For example, if you are a contracting officer's representative coming in on the metro this morning and you noticed in today's Washington Post Express that the contractor that you work with on a daily basis, the president of that company, was indicted for falsifying bank loans for his personal business, that is a basis for suspension and debarment, so you could pass that information along to the Inspector General or suspension and debarment official, because such allegations, especially if it's a small company, really do speak to that person and their ability to conduct business generally, not only their personal business, but also the business that they would do professionally with the government. Finally, communicating with the suspension and debarment official is important if you have any questions. The vast majority of suspension and debarment officials throughout the federal government do have an open door policy and encourage lines of communication to be open. If you at your agency do not know who your suspension and debarment official is, there is a links page in this presentation that you can click on to find information about the individuals, including the suspension and debarment official and individuals who work in his or her office that are points of contacts and sources of reference for you. One last thing to note is be careful of de facto debarment. What is de facto debarment? This is using means other than the formal suspension and debarment process laid out in FAR 9.4 to effectively and systematically exclude a contractor from federal procurement and non-procurement programs. This is a problem because if you are taking it upon yourself to systematically and continually exclude a contractor or potential contractor from federal procurement or non-procurement programs, the contractors do not have the opportunity to present their case, present matters in opposition, and to give their side of the story, such as they have in the 9.4 suspension and debarment process. So areas you may want to be very careful, because this is where we've seen de facto debarment cases arise, are three areas that we'll talk about today. First, within FAPIS, the misuse of administrative agreement information. Administrative agreements are required to be posted on FAPIS, and they are viewable by the contracting officer. These agreements do detail past wrongdoings. However, the past wrongdoings should not be considered by you in terms of whether or not contractors should be awarded. This information is there publicly, but the suspension and debarment official has already made a determination that despite this past wrongdoing, the contractor is presently responsible and can contract with the federal government. Next, the SAM inactive section. After the suspension, proposed debarment, or debarment has expired, for a number of years, this entry will live on in the inactive section. However, the time that they were excluded has passed, and this past information should not be dug up to prevent a contractor from being awarded a contract or an option to be exercised to this contractor. And finally, state-level suspension or debarment. If you find out that the contractor has been suspended or debarred at a state level, you automatically do not use this to say that the contractor is suspended or debarred at the federal level. It doesn't necessarily work that way. This may be something that factors into a responsibility determination, but just because they're suspended or debarred at that level does not mean that automatically the contractor is excluded federally from procurement or non-procurement programs. Here are some important links. First, the System for Award Management, sam.gov. Second is the Interagency Suspension and Debarment Committee website, which has a link there that provides you the information I talked about earlier, contact information, emails, phone number, addresses, things of that nature for suspension and debarment officials and for those who work in his or her office in different agencies. The Inspector General's Directory. This is similar to the list for the Interagency Suspension and Debarment Committee that has contact information for offices of Inspector Generals throughout the federal government. And finally, FAR 9.4 is listed here for your reference. So at this point, we're going to switch gears here and go into questions and answers. So first, we'll take a quick look at acronyms. Acronyms that were frequently used throughout the presentation that you may not have caught their first go around when we define the acronyms are as follows. When we referred to the SDO, we were referring to the suspension and debarment official, the individual with the authority for a particular federal agency to exclude parties from procurement or non-procurement programs. P4Ds are proposal for debarment letters that exclusion from federal contracting. SAM is the System for Award Management. EPLS is the system that listed excluded parties previously that has been rolled into SAM. ORCA, Online Representations and Certifications Application. And CPARS, the Contractor Performance Assessment Reporting System. Questions about who can be suspended or debarred here. Can we debar state or local officials? Yes, state or local officials, given their knowledge, skills, ability, and connections, may fall within the definition of a contractor and are with regularity excluded from federal procurement and non-procurement programs. Where does a subcontractor fit into eligible entities for suspension and debarment? A subcontractor, if you look at the definition of contractor within FAR 9.403, is an entity that may be suspended or debarred because you're not only looking at the ability of a contractor to submit awards at the prime level, having direct privity with the government, but also at the subcontractor level, contracts that may be let under a major federal contract. How long does it typically take from start to finish to suspend a contractor? And is there a backlog of requests? Typical start to finish time varies depending on the level of complexity of a case, whether it's a single individual, whether it is a company and a number of related companies or individuals. It can take anywhere from a business week to much longer, 6 to 7 months, just depending on the complexity, the facts that are available, the facts that need to be developed, and the legal review process that occurs, and also the contracting party, the contractor, his or herself, or the entity, does have the opportunity to respond, which can also significantly lengthen the time from initiation of a case to the conclusion of a case. And finally, is there a backlog of requests? This varies from agency to agency, and the referral cycle does have its own natural ebbs and flows. So at any given time, there may be a couple of cases that are being in the queue while others get worked on, and at other times there's no backlog.
Okay, so I'll answer the next few questions we got. Number one is, should we look at the S&D archive for assessing past performance in contract award? The short answer for that is no. And the reason is, Danielle explained earlier about de facto debarment. The suspension and debarment process that is set up to give due process or fairness rights to the party that's suspended or debarred or proposed for debarment. And so if you look on the archive and make a determination that this contractor or person is not eligible for award, what you're doing is actually performing a de facto debarment, basically debarring them from getting any business with the government without giving them the due process of coming to defend themselves. So you should not use an archive to determine whether or not to award a contract to a contractor. The next question is, should all bids be checked in sam.gov? Whose responsibility is this, the CO or the CORs? Yes, all bid, and the FAR does outline that contracting officers, and that's the responsibility of the contracting officers, should check FAR twice, once at the receipt of bids and once immediately prior to award. So yes, and yes, it's the CO's responsibility. Next question. When we check SAM, do we search a company by their name, or do we search by the names of the key individuals to determine whether they are suspended or debarred? The answer is both. You need to check the name of the company, and you need to check the name of individuals, because you want to make sure you do not miss anything. And sometimes, just depending on how a name may be listed in SAM, you might miss something. So it is best to check both, because you do not want, as a contracting officer, to award a contract to a suspended or debarred entity.
I'll pick up the next few questions. We received a question, how can a debarred contractor be reinstated? Within sam.gov, when you enter a suspension proposal for debarment or debarment, there you need to put an end time. For suspension, that typically is indefinite. For proposed debarment as well, but once you get to that debarment stage, you do need to enter a termination date. So once the debarment terminates, the contractor goes to that archive section for the exclusion, and the contractor is able to do business again with the federal government. There is no formal reinstatement process other than that name going into the archives or inactive section, which it is now called on SAM. This goes directly into the next question. After the debarment period, are individuals or companies' names removed from the debarment list? Yes, automatically, and they go into the inactive section. Finally, before I turn it back over to Maria, are there any instances that can lead to a permanent debarment? Suspension and debarment, looking at the non-statutory suspension and debarment actions, are all fact-based and discretionary, and the egregious nature of a particular action in conjunction with the contractor's relationship with the federal government may lead a debarment to go outside of that typical 3-year period. So really just depends on the nature of the facts that may lead a suspension and debarment official to decide that the federal government's interests are only protected by a permanent debarment of that contractor from doing business with the federal government.
Okay. I'd just like to add to that is not normally the case. The institution of a permanent debarment is a rare exception rather than the rule. So the next question is, are you allowed to exercise an option year to a suspended or debarred contractor? The answer is no, and the FAR clearly prohibits that. However, there might be circumstances where a compelling needs determination might be made by the agency head that it is necessary to award to a suspended or debarred contractor. And this generally happens in the case where there is a need that is highly critical for the service that the contractor provides, and the agency cannot get it from any other contractor, or the cost of obtaining it from another contractor would be so high that they're prohibitive, and that would not be in the best interest of the government. But the general rule is no, an optioneer is not exercised to a suspended or debarred contractor. Next question, why would you issue an optioneer to a suspended or debarred contractor? Actually, I just answered that question, so we can skip to the next one. Is there a notification to those currently contracting with a contractor that is suspended or debarred? No, there's generally no notice to subcontractors of a contractor that's suspended or debarred. The contractor itself or individual, him or herself, receives notice, and the best advice is for somebody who's contracting with that contractor to regularly check SAM just to see if that contractor's name does appear on the list. And Danny, I'll take back over.
To add on to that, when an agency suspension or debarment official takes action against a contractor, it is not common practice that the suspension and debarment official notifies the contracting shop within the agency that a contractor is suspended or debarred. So again, it's doing those routine checks of SAM when it comes time to exercise an optioneer, etc. On contractors where the suspension and debarment official knows that it's a high-profile contractor that the agency frequently does business with, in that instance, it is more likely that the contracting office will get notification. But no, again, that's not a routine practice. Another question we received, what are the most common leading indicators to look for that might lead a Corps to recommend action against a contractor? Here, it's kind of, as I like to call it, for a lack of better phrase, the sniff test. Does it not smell right? Is there something that a contractor is doing or failing to do that relates to contract requirements or general ethics and compliance rules that you think is funny, that they're not doing, that they're doing something that just doesn't match up? So document and prepare a memo or whatever is your office practices and passing that along. Better to be overcautious than under, as the Office of Inspector General and Suspension and Debarment Official also will be looking at this, and the more information, the better. Another question, since we have no privity of contract with subcontractors as the government, what is the best practice when we believe that undocumented workers are hired by subcontractors? Two different avenues here. First, report it to the Office of Inspector General through your office's policies and let the Office of Inspector General investigate this. Another way is through bringing this to the attention of the prime contractor. The prime contractor's requirements, which include hiring legal workers, all come down to the subcontractors through flow-down provisions, and the prime contractor is responsible for the subcontractors following those provisions. The last question I will answer today before turning it back to Maria is, how do you know if your contractor has not filed its tax return? I believe this question is going to the tax delinquency issues and information that I brought up toward the end of the presentation. How GSA has handled this and how other agencies have followed suit is through contractors being required to complete a certification with any bids or proposals stating checkbox, yes or no, I have filed my tax returns. So here would be looking at that tax certification and seeing if the contractor has answered in the affirmative or the negative and acting accordingly.
Okay. Now the question is a little bit long, so I'll read it. There is a company that has overseas and domestic operations. An employee in one of the overseas posts did not use proper government procedures. The company president initiated an investigation and then alerted the United States government with its findings. The United States then suspended the entire company from doing business with the government. Is this a usual practice, excluding based on a rogue employee? We do suspend or debar companies based on the actions of its employees. However, each case is different, and in this scenario that you present, if this is truly a rogue employee that went off on his or her own and acted without the knowledge or consent or acquiescence of this contractor, then it is conceivable that the SDO might isolate that employee, depending on how the company, of course, reacted to this wrongdoing once they found out about it, and only suspend or debar the rogue employee. However, if there is any evidence that the company knew of, participated in, or should have known, or was otherwise just not responsible in how its controls were set up or its procedures were set up, that could lead to the determination that the contractor is not presently responsible, and could also result in its exclusion from government contractors. So I wouldn't say it's a usual practice to debar a whole company based on simply on a rogue employee, but it really is fact specific as to what decision the SDO makes. The next question is, why would I need an attorney? This is a good question. This suspension debarment has such a far-reaching effect. It could completely ruin your life, or ruin your career, or just completely affect your livelihood. And if you do not know what you are doing, it just like in a criminal case, you would go get an attorney because you're not familiar with the rules. This is the same. It's the same thing. Most companies, of course, would have an attorney because they're companies and they do have attorneys. So that's what their job is. But for an individual, if this is something that you know nothing about, or would want some help in, it is advisable to get an attorney. And the next question, who pays for the attorney? Does the government provide one? No, the government does not provide an attorney. You, the company, or you, the individual, pays for your attorney if you choose to have one. Remember, it's not a requirement. It's just, but if you do choose to have one, then that's your responsibility. The next question, in the gas card example, how long would the former government employee be debarred? 3 years, more or less. So, as we stated in the presentation, a debar generally lasts 3 years. It can be a little less or a little more depending on the facts of the case, but generally it would be 3 years that a debarment lasts. And the final question is this: if a company has been suspended or debarred, how do you track if they have created a new company or entity in which to contract under? This is a very good question, and it happens quite frequently that companies who are suspended or debarred do actually shut down and start up again. And so we do not have a tracking mechanism, and there is no perfect way to catch all of this. However, what I had explained to you before about affiliation was one way in which we track or we can find out whether it's the same company that was suspended or debarred before that is now starting up as a different company. Remember, we look on issues such as common management, common address, the ability to control. So if there's some commonality between the suspended company and this new company, that will then lead us to further investigate to see if that's indeed what has happened. And so, although we don't have any formal tracking systems, we do have what we call the sniff test, as Danielle said, that will say this sounds funny or looks funny or smells funny, and it would lead us to investigate. Unfortunately, we don't catch all of them, but for the most part, when we are suspending or debarring a contractor in the first place, we do look to see if there are any affiliates or anybody can be associated by imputation, and try and cast that wide net in the beginning so that we actually are not faced with this problem. I think that's it for all the questions. I just want to thank you for your time. Our contact information is included on the presentation, and as I said before, at some point in the near future, the entire presentation will be up on fai.gov. Thank you.